afternoon, everybody. This is John Giardinelli. I'm the association attorney, and this is John's Rants. What I decided to do today is, because the market is so insane, is to talk about a couple of issues that have been coming up through the actual cases we've been seeing. So the first thing I want to start off with is a major concern of mine, which is practicing law without a license, specifically the escalation clause. I've got two stories to tell you. In one case, very simple, not complicated. The realtor making the offer on the addendum form, which CAR provides, simply typed in offer to be $5,000 over highest priced, comma, subject to proof. The other one is a little more complicated. Basically, the offer indicated that it was to be $10,000 over the best price, as $1 million plus property. Again, subject to proof, and that person put in a cap. So in both cases, we have problems. In one case, of course, the argument has to do with the level of proof and the fact that no cap was put on the offer. And in the other case, it's much more complicated because the listing agent had signed a non-disclosure agreement. And so now you have a situation where the buyer's agent was told, well, you've got the property. Our best offer was, and I'm going to pick a number, $1,200,000. So you're going to pay $1,210,000. And here's a picture of the offer that we got for the 1.2 million, but he would not produce the entire offer as was corrected. In both cases now, the issue really, and they're both in dispute. One is actually going to go to an ethics hearing, and the other one is a breach of contract claim. In both cases, the problem is this: what proof are you asking for, and can the seller provide it? Because again, you have issues with other people's offers and privacy and all that. Generally speaking, because there usually are not going to be non-disclosure agreements, the suggestion is that you, number one, indicate how much you're willing to go over the highest price. Number two, that you cap it at whatever figure your buyer is telling you to cap it at, or whatever has been agreed to. Number three, you clearly define the proof that you want in order to establish that, in fact, that bona fide offer is legitimate. On the seller side, please remember that you have a duty to tell the truth, that it would be fraud to make up an offer that did not actually exist. But now you're stuck, again, if you have some other side agreement or other agreement with, what do you do? A couple of tips. Number one is go into the CAR website. They have a really good quick guide on escalation clauses. Number two, have an attorney take a look at what you're doing, particularly at the numbers that we're seeing right now, because again, in both of those cases, lawyers are now trying to sort through what was frankly potentially problems for the realtors. Another issue that's coming up that we've been getting a lot of calls on are contingencies that are being waived. And of course, we understand that people are doing that in this market. I had dinner with a realtor who's in a leadership position at a board in Tennessee the other night, and she was telling me that it's not uncommon to have 15 or 16 offers in that region, as well as the market here. So people are waiving contingencies and making all sorts of offers, escalation clauses and things like that. But we've seen a bunch of problems with this. Number one is you need to make sure in both the escalation clause issue and in the waiving contingency issue that you carefully document your file so that you can prove later on that you were not, quote, talking the buyer into something. And so let me tell you some of the issues that we've seen. There's a contingency waiver. The buyer can't close on time, and the buyer now wants their deposit back. Well, if there's no contingencies, there's going to be a fight over who gets the deposit back. And the problems that we've seen are where the realtors make statements such as, "Oh, don't worry about it. The seller's going to get the deposit. Don't worry about it. There's still other ways of getting the deposit back." You need to understand that those are going to be legal issues, and you really ought to stay out of that conversation. Other cases that have been coming in deal with the appraisal issue. In one case, the buyer made an offer, waived the appraisal contingency. The appraisal came in at far less than what they were offering, which is probably not unusual in this market, and they now want their deposit back. And of course, the seller is saying you can't have it back, and the buyer also wants to renegotiate. And there's nothing that now would require that seller to renegotiate, and now you end up with an argument because, again, the parties didn't think carefully through the what ifs. And so in both cases, lawyers are now trying to sort through those issues. Another fairly common problem that seems to be coming up a lot in the phone calls we're getting is where the seller is demanding that there be waivers of all of the inspection contingencies, but that doesn't mean that the seller is relieved of all of their obligations to properly disclose all material facts and all material issues that would affect the value and or the desirability of the property. Again, while you are waiving your right to the contingency that if you don't find the property suitable, you can cancel the contract and get your deposit back, the fact remains that have you also waived your rights to the inspections? Because simply saying we're going to waive our rights to get the deposit back if we don't have a satisfactory inspection doesn't necessarily mean you should not have the inspection. And in fact, at that point, the inspection takes on even greater importance. And then one of the issues that in talking to other lawyers and in listening and reading and all of that is I believe, I could be wrong, I hope I'm wrong, but I believe that we're going to see a time where tremendous buyer remorse is going to set in. Either I bought a property sight unseen, I waived my rights to inspection, didn't realize there were all these problems that the seller didn't know about that could have been discovered during an inspection. I paid way more than what the property was listed for and what the appraiser said it was worth. And now the market is adjusting itself and I find myself in a house that isn't worth what I paid for. And I have buyer remorse. And I believe, and many other lawyers that do what I do believe, that at some juncture, we're going to see that result in additional lawsuits where buyers try to find a reason to go after their agents and or the sellers or both. And I think that you need to be very, very cautious. And again, a lot of this boils back to staying out of areas where you're not qualified, making sure that everyone understands that the law is still the law, the TDS, the seller property questionnaire, all those things are still important and necessary, making sure that your file is documented, that it is absolutely clear that the buyers especially are fully aware of what they're waiving and why they're waiving them, and that I've said to you as my agent, look, I understand that if I have any chance of getting a property, then I'm doing this, this, and this, and I You have explained to me what all that means, or you have provided me with checklists, or you have provided me with advisories, and that I will read them or have read them, and I am fully aware of my rights that I am waiving and the other issues. Another issue that comes up a lot, we saw really interesting, two really interesting sort of plays on this, are the so-called love letters. The other day, the association hosted a fair housing symposium. You had a representative from the Department of Fair Housing strongly urge you to stay away from the love letters. The California Association of Realtors has strongly urged you to stay away from the so-called love letters. The representative from the National Association of Realtors who was on the panel strongly recommended that you stay away from these love letters. In fact, a revised listing agreement is out, and in that listing agreement, there is a place for you to now insert that you have had conversation and received direction from your client as to how to deal with these love letters, that you don't want them, you're not going to accept them, and you're not going to have anything to do with them. A couple of issues that popped up lately. First of all, a couple of tips. Well, let me just talk about the two cases. In one case, the property was in a substantially Caucasian neighborhood. There were almost 20 offers in the first 2 days that the property went active. There were bids way above the list price, and in fact, the property did sell for substantially more than the list price. And in one of the cases, a buyer who turned out to be the successful buyer knew a lot of other white people in the neighborhood and wrote a love letter, and it was purely innocent, at least in the mind of the people that were involved. And it said essentially that I belong in this neighborhood, I love this neighborhood, I have friends in this neighborhood, I will fit into this neighborhood. And there were questions about whether that language was in some way a fair housing violation, because what in the minds of some people who looked at that particular situation, I was saying was, hey, I'm white, you're white, I belong here, I'm going to fit in, I look like everybody else in the neighborhood, and now you have issues. The other was kind of an interesting case. The love letter was in the form of a video chat where the listing agent was having a video chat with the buyer's agent, and there were many offers on this particular piece of property, and the buyers happened to be in the room with the buyer's agent during these conversations, and they were African American. And at one point, the seller could see them on the video. Now, those people did not get the property. And of course, the claim is I sold it to other people because the offer was better, and the terms were better. And again, what you end up with is a situation, maybe purely innocent, where you now have a dispute because the people that didn't get the property believe, and probably with some justification because of the history that they've had to face, that the reason they didn't get the property was because of the color of their skin. And of course, that could play out in all of the other characteristics that go into fair housing. It could be gender identification, it could be ethnicity, it could be race, it could be all sorts, immigration issues, it could be language issues. So you need to be really careful about that, and have these conversations with your seller and make it clear that everyone is going to be given the same information. All of the same questions are going to be asked, and all of the same documents are going to be provided, and no one is going to get anything different because of the characteristics that they have. Additionally, there's not going to be any conversation about these issues, and you're going to allow buyers to see properties they want to see, regardless of areas. You're not going to tell them, well, you don't really want to see that neighborhood because of some reason other than the fact that that neighborhood is not integrated or something along those lines. A couple of other issues, and I will leave you for the day, and we'll revisit some of this next month. Be really careful about making sure that your sellers get all the offers. You have a duty under Article 1 of the Code of Ethics to provide. Oh, the lights just went out. Let me do that. There we go. Apparently, I've been sitting still for too long. Sorry about that. You have a duty to provide all offers of any kind to your sellers unless you have a written instruction to the contrary, and it better not have anything to do with any of the fair housing issues. If you fail to provide your seller with all offers, it is conceivable that you will face a strong ethics claim. But just as significantly, according to the Department of Real Estate, if you fail to provide all offers and you end up with both ends of that transaction, it is conceivable that you're going to have an investigation started at the Department of Real Estate because you have damaged the consumer. It's not going to be an issue because some other agent didn't get their commission because you hid information from them. The Department of Real Estate takes the position that that's a board issue, and the board, the association, can take that issue up. The issue is going to be that you damaged a consumer. A couple of quick comments. We're going to be sending out a newsletter analyzing all the new and revised forms, so keep an eye out on that. And the new RPA agreement is now final as of the 23rd of June. In the year 2021. So we now are going to get ready to start teaching classes. Keep an eye out for that. The association is going to do some live classes. I'm going to do a class or two with one of the better training brokers in the association. So keep an eye out for those announcements, because the brand new 16-page RPA is now final. It will come out in December, and it is significantly different. It's, in my opinion, much improved over the RPA you're going to use until December. Keep in mind also that there will be significant changes to many of the forms. Some forms are going to be integrated into the contract. Some will be revised to fit into the contract, and others will be sunsetted because they won't be necessary any longer. And the training will cover all of that. Your association, as well as the California Association, will be doing an abundance of training depending upon your experience level. We're going to do training for those of you that are a little bit more advanced, maybe been around a little bit longer, and then we're going to do some specific and more detailed training for those of you that are newer, a little less experienced, maybe need a refresher course. So keep an eye out for that. Those classes should start in August and September, and we'll keep you posted. For now, John's Rants is over and out, and we will see you next time. Thank you.